Hello, everybody. It's attorney Laura Sterling. Welcome to my spooky Halloween live show. I know I said at the beginning of the month that I was going to go scarier, but I really wanted to kind of tone it down for my live. I didn't want to scare anybody of you out there that might be scared. So I just thought I'd have the Snoopy and the pumpkin and the moon and the bats. Because as you all know, my precious little dog Snoopy, he's as cute as can be. And I don't know if you know, but I got a second dog, Lucy. Not quite the connection. Anyway, they're put away. Somebody told me recently that dogs prepare you for kids and cats prepare you for teenagers. So I kind of laugh because it's true. But anyway, I want to welcome you to my live. It's October 31st. Can you believe it? 2 months. 2 months. What is that? I think there's 61 days or something left of the year of 2023. I hope that 2023 brought you happiness, health, wealth, all of that stuff. I think that 2023 was very challenging with everything that's been going on and everything that continues to go on. So I hope that it ends for you on a good note. But it's hard to believe that now we're preparing. I mean, the kids are going trick or treating tonight. I don't know about you. I don't get any trick or treaters. My house is pretty far back and we have a lot of woods. So it'd be kind of scary for people to come back here. So we don't usually get trick or treaters. And then tomorrow, we start preparing for Thanksgiving. We put away the Halloween things and we take out the Thanksgiving. And then it's going to be Christmas. It's crazy. It's just crazy how time flies. But as I like to do, last month I talked about guardianship. And this month I wanted to talk about estate planning because as it gets to the end of the year, people kind of look at things. They look at planning for taxes, of course, here in the United States, our taxes that will be due come the beginning of the year. They look at how to best get their tax breaks so they don't owe the government so much money. And then also, do I have everything in place? Do I have everything that I need? What if something happens to me, God forbid? Is my stuff going to go to my family? Do I have somebody to be in charge of my belongings or my finances or my health care if I become ill or fall ill? All of these things are things that are kind of examined at the end of the year. I always look at it as the end of the year or the beginning of the year. The beginning of the year, it's a fresh start. What should I do? I should look at my estate documents or even start or do my estate documents. And so that's why I felt October is always a good time of year to do that because, okay, we still have a couple months till the end of the year. We can kind of see, hey, if maybe some estate planning can help you financially, tax wise. So that's why I like to go over estate planning. And it's also kind of a lightweight, easy kind of topic to talk about. We don't get too much into depth, like with my criminal lives, those can get kind of hairy. And my family ones, they can get very emotional. So with estate planning, it's always a good thing. And anytime I sit down with clients that come in for estate planning, they always come in, it seems like, for one document. Well, I'd like a power of attorney. Well, okay, let's talk about this. Power of attorney, living wills and trusts, healthcare surrogates, all that is a bundle. You don't want to just do a will, but you don't have a power of attorney and a living will and a healthcare surrogate. So a will is good to deal with things when you pass away, but what about when you're alive? And maybe you can't take care of things or you have nobody to take care of anything. Maybe you never had children, you never got married, all your siblings and your parents are deceased. Somebody needs to be named because otherwise, who's making healthcare decisions for you and who has access to, here in the United States, depending on when you pass away, Social Security, pensions, retirements, even your bank accounts, anything like that. So always when clients come in, I always do a bundle. I say, let's talk about everything. Let's just put everything on the table. And then I talk to them too about how to avoid probate. Shh, 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 shh. Don't tell anybody I'm telling you this. So kind of keep it on the down low. But what are some ways that you can avoid probate? And I'll go over that a little bit at the end to just kind of give you a little tidbit, something to chew on afterwards. So, okay, well, I think I've jibber jabbered long enough. As I told you the last time, newscaster Laura, she's on a little break. I'm just really going to call her back when we have something pertinent. usually when the law changes or there's something new to add to the law that I want to fill you in on. Then I'll have her come back from her little retirement, although she seems to be enjoying retirement and traveling all over the place. So I give her credit for that. She's worked long and hard. She worked what, a year for me, or maybe a few months, doing the news. So she's very exhausted. So take a deep breath. I know I need one to begin. And grab your little drink. I have my little drink. I ran out of water bottles, so now I'm into my glass. Grab your drink, your popcorn, your snackies, your little pad of paper, your pen, or your electronic device to take notes. And please, 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 if you have any questions, please put them right away in, because sometimes we get to the end and you're like, oh, wait a minute. And you're putting in your question and we'll have finished and I didn't get to answer your question. And I always want to make sure I'm taking the time out to spend with you and you're taking the time out, which I'm very honored that you're taking the time out to spend with me as well. And I want to make sure that your questions are answered. I always do that when I meet with a client at the end. Is there anything else you want to ask me? Because I want to make sure that I answer your questions, because I want to make it worth your time. So make sure you're comfortable, get yourself all settled in. Either you have the heat on or the air on. Now, I just came from Minnesota. If you follow me on Facebook, when I left there, it was 23 degrees Fahrenheit, not Celsius, Fahrenheit. And it's only getting colder up there. So I'm back here in sunny Florida, thank goodness, with my 80-degree weather. And the humidity is pretty light right now. So I have my air going. But wherever you are, sit back, relax. Now, know that when I talk about the law, I'm going to talk about it specifically to the state of Florida. But please know, whatever state you're in, it's best to contact an estate attorney to find out, hey, this is what I heard. Can you explain to me what the law is here in Minnesota? Now, I do know a little bit about the law in Minnesota because I helped my parents get all their documents together with their lawyer. But I'm not going to talk about Minnesota because I don't have a Minnesota bar license. So make sure you get with an estate planning attorney in your estate to get clarification on what the specific laws are in your estate. All right, let's start. We're going to start power of attorney. What is that? Now, anytime I get people that are their first time coming to me, or maybe they've heard stuff and they always say, power of attorney, we'll have to appoint an attorney to be in charge of my stuff. No, 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 no. Just because it says attorney in the title doesn't mean it has to be an attorney. It should be a family member, a friend, somebody you trust. Now, if you don't trust anybody, you might want an attorney, but, or some kind of trust company. But a power of attorney is generally somebody that you trust. The power of attorney, now there's two power of attorneys here in the state of Florida. And let me explain them to you, the differences. There's a regular power of attorney. And at the top of the document, it'll just say power of attorney. That's it. It may say power of attorney for Laura Sterling. It may say that, but power of attorney. What is the power of attorney for? Let's say I'm going to live overseas for a year. I'm going to go live in Ireland. I love Ireland. So let's say I'm going to Ireland to live, but I have a piece of property here in Florida and I want to sell it. And I have a buyer. Oh my goodness, I'm in Ireland. I mean, there's a lot of technology nowadays, but still, I need somebody to take care of things for me because I'm unable. Maybe I'm working, time difference, there's 5 or 6 hours difference. So I appoint somebody to be my power of attorney to sell my house. That's all they're doing. Once the sale is done, that power of attorney is null and void. So let's say I give the power of attorney to my parents. I say, Mom, Dad, here, I need you to sell this house for me. I need you to deal with the title company. I need you to deal with the mortgage company. I need you to deal with the realtor, with the closing agent, all of that. I need you to deal with that. So what I do is I draft up a very specific, I have a hard time saying that word, very specific power of attorney. You can tell I used to have a lisp as a kid. A very specific power of attorney that explains and spells out exactly what their powers are. And I would put that in there to deal with my mortgage company, deal with my title company, to deal with the realtor, to deal with the sales. All of that would be spelled out. And that's all they can do. So they can't go, he, I have a power of attorney. I'm going to go liquidate all of her investments. I'm going to go take all the money out of her accounts and I'm going to have a good time. No, it doesn't give them the power to do that. It's very specific. And like I said, once a transaction is done, the power of attorney is done. They no longer have that power. Period. Now, let's say my parents are halfway through the sale and suddenly something happens to them. They are unable to complete the transaction. God forbid something happens to them. Now, I always tell people in a power of attorney, in any document that I'm going to talk about, and I'll remind you every time I talk about a document, to put an alternate. Please, please, please always put an alternate, because what happens if something happens to my parents? What's going to happen? The transaction's now dead. If I have an alternate, though, let's say it's my brother. So I put my brother as an alternate, then it reverts to him. So the language would say, I appoint my parents, their names, as attorneys in fact to deal with the sale of the property. However, if they're unable to, something happens, they're unwilling, they just can't, they say, this is too stressful, I can't do it, then I appoint my brother to work as my attorney in fact in the sale of my home. So we have that. So it's a backup. It's there. I don't have to worry about it if something happens. I get that a lot from individuals who appoint their parents, and maybe they say, well, my dad, he's kind of elderly, he's in his 80s. And what if something happens to him? Have an alternate. So it works, and it works well. So that's what a regular power of attorney is. Again, just specific to that task. Now, a durable power of attorney, same thing, power of attorney. I'm appointing somebody to do something for me. A durable here in the state of Florida means it lasts. It even lasts past my incapacity. If I become incapacitated, that durable power of attorney still stands. And that durable power of attorney generally spells out everything that my power of attorney can do. So what it'll say is dealing with all my bank transactions, investments, securities, insurance, hiring attorneys, hiring accountants, taking care of investments, dealing with the bank, drafting qualified income trusts, whatever it may be, it's spelled out in there. Ours is pretty extensive. I mean, I do 3 pages, although I've seen, longer and I've seen shorter, but ours is 3 pages. And I think it covers about 22 points in there. And the last one, I always throw it in there, and any healthcare decision making. So it becomes a durable medical power of attorney because it deals with healthcare. So I put that in there. And then what happens is I have to sign, in the state of Florida, I sign my own power of attorney. I am the only one that can appoint a power of attorney for me. I get this question a lot too. Well, if something happens to Judy, or let's say if something happens to my parents, they can just appoint my brother to be power of attorney. No, that cannot happen. The power of attorney does not have the power to appoint somebody else as your power of attorney. They cannot do that. I just had a conversation with, probably about a 5-minute conversation with a client about that, because he kept saying, oh, well, that's okay. Well, I'll just appoint someone. No, you can't. The individual has to appoint somebody. I'm the only one that can appoint a power of attorney for me. Nobody else can do it. Not my husband, not my son, not my parents, not my brother. Nobody. Because to do a power of attorney, I need to have the mind to know this is who I want. I have to have the ability to choose that individual. So nobody else can do it for me. I have to be able to do it. So that is what we call a general power of attorney, meaning it addresses a certain task or a certain topic. And then a durable power of attorney lasts beyond my incapacity, and it covers more. It covers all of that stuff. It seems to me when I do a durable power of attorney, somebody always comes back. Not everybody, but once in a while, somebody will come back and say, Say, I just had this recently. Say the bank won't let me open a qualified income trust because it's not specifically stated in the durable power of attorney. Although it says that you're able to open up any accounts, any bank accounts, anything like that, they wouldn't let them open that. I'm like, are you kidding me? I mean, banks are getting more and more difficult. So I just drafted another one. I included the qualified income trust information, signed it, and he was able to take care of it, no problem. So, hello, Alice. Hey, it's Alice here. I've often wondered if I give someone power of attorney, what are the God bless Alice. I like your question. You're thinking good. What are the chances things could go sideways? And so when you say sideways, I'm assuming go awry, go wrong. Good question, and I'm glad you brought it up. The moment you sign those power of attorneys, they go into effect. The moment. So you can't say, well, this is just for in the event that I become incapacitated. No, the power of attorney comes into effect immediately. So, Alice, you always want to make sure that the person that you appoint as your power of attorney, number one, is somebody you can trust. Number two, it's somebody you want to sit down with. You want to sit down and go, hey, listen, this is the job I want to give you. I want you to be my durable power of attorney, or I want you to take care of this for me. Can you do it? And let me give you some instructions in the event that something does happen. This is what I want done. So it's a yes, you're right. They can go take that power of attorney. They can go to the bank and say, I'm power of attorney, and I have the ability to clear out this account. So I always say, too, it, unless it's for a specific thing, like to sell a house and it's valid right then, you're selling the house right then, give them a copy of that. Or if you have that durable power of attorney, say, okay, mom and dad, I've appointed you as my durable power of attorney, but I have it in my desk drawer to the right under lock, and the key is in the top drawer, so that they don't have immediate access to it, but they do know where it is in the event that they need it. So, very good question, Alice. It should always be somebody that you trust. Yes, things can go awry. You can always pull. That's another good thing, Alice, to bring up is you can always pull that power of attorney too. You can make it null and void. You are no longer my power of attorney. Make sure all your banks know all of that kind of stuff so that they're aware. But excellent question, Alice. And thank you so much for bringing that up. It's always kind of scary, when you're appointing, because you never know. You never know what could happen. And I had a power of attorney of her grandmother one time, million years ago, when I was working nursing homes, that tried to null and void her grandmother's living will. And we'll get into a living will in a moment, but she tried to null and void her grandmother's living will as a power of attorney. You can't do that. You have certain rights enumerated in there, and one of them is not to disband a living will. So it always has to be somebody you trust, especially if it's healthcare decisions as well. And we'll get into that with the healthcare surrogate, which we might as well just roll right into it. Let's talk about healthcare surrogates. Let me take a little drink of my little water. Healthcare surrogate. What is that? Kind of like a power of attorney, although a power of attorney goes over financial, and then I always put that little healthcare decision making in it. But the healthcare surrogate is strictly just for healthcare decisions. So again, myself, and I are the only ones that can appoint a healthcare surrogate for myself. That's it. My power of attorney cannot appoint somebody to be my healthcare surrogate. Maybe the nursing home or the hospital I go into can't appoint somebody as a healthcare surrogate. That's a healthcare proxy. That's a different issue. A proxy is where you never appointed anybody, and the institution goes out and tries to find somebody where they can appoint somebody as a decision maker. And in Florida, there's a succession of people who can do that. Starting out obviously as a court appointed guardian that we spoke about last month. Then there's a spouse, adult children, parents, all of that. It goes through all that. I've actually had somebody one time find a friend of somebody at a local bar. They had found out that this individual frequented this local bar. So they went to the bar and said, hey, this person's in the hospital. They need medical decisions. Does anybody here know? Oh, yeah, I do. And he actually turned out to be a really good guy and really made some good decisions. He said, listen, I've known him for 10 years. Yeah, he comes in here a couple times a week and we chit chat. So, can be a close friend if there's absolutely nobody else as you go down the succession. Healthcare surrogate, I can appoint. I can make that decision. So again, let's say I appoint my parents as my healthcare surrogate. Again, I'm going to repeat myself like I'm going to throughout this hour or however much time we have left. Always choose an alternate. Always, always, always. Because if something happens to my parents and they're unwilling or unable, I want to have somebody as a backup. So I appoint these people, I sign off, two witnesses notarized. Now, their healthcare decision making abilities, unlike a power of attorney, doesn't come into effect until I'm unable to make decisions. Because under HIPAA, HIPAA, the privacy laws with our medical, the doctors and healthcare providers have to come to me first. As long as I'm able to make those decisions, I'm competent and I'm not incapacitated, I can make those decisions for myself. They may not be what my parents would want, but it's me and I can choose what I want done. So they'll come to me. The moment I'm unable, I become incapacitated, I become in a persistent vegetative state, whatever it may be, that's when the healthcare surrogate kicks into place. Hi, Andrea. Oh, what a beautiful name. Hey there, it's Andrea. So, a couple of years ago, my dad fell seriously ill. I'm so sorry. I know I had an incident a couple of years ago as well with my dad. Within weeks, he became incapacitated and couldn't make decisions for himself. So, my question is, how can one ensure that the healthcare surrogate truly follows my dad's medical wishes? I don't know, you guys have some excellent questions. Just like I said with the power of attorney, it's hard. It's hard when you're the individual you've appointed. Let's say, Andrea, your father appointed you to make healthcare decisions. What I would recommend to him when he appoints you is to say, first, sit down with your daughter and have a heart to heart conversation with her. Make sure that she can abide by your wishes. So let's say your father sat down with you and said, if I ever become incapacitated or I'm in a persistent vegetative state, there's no hope of recovery, I'm in a terminal condition, and we'll talk about this in a moment with a living will. Please, please don't keep me alive by extraordinary measures. Please just keep me comfortable and make sure I'm pain free. And being truthful with your dad, say, Dad, I can do that. I can do that for you. Of course, when the time comes, sometimes it's a little more, it's such a decision to make, right? But understand if your father, in his living will, which again we'll talk about, and in his conversations with you or in his healthcare surrogate, and he told you what he wanted, or even, years prior, he's talked to you about what he wants. My mother keeps talking about every time we're at church, when I'm up visiting them and a song comes, she'll turn to me, this is the song I want at my funeral. Really, Mom? Really? Can you just make a list? Anyway, but if he's ever spoken to you about it, you know in your heart that you making that decision is not your decision. It's not your decision. If he verbalized to you what he wanted, it's his decision and you're honoring that decision. Now, if he didn't have that frank conversation with the person he was appointing as a healthcare surrogate, and I'm scared, I don't want to do that, I keep him alive by any way you see how or fit. And like I said, I've had that in the past. I had a woman in the nursing home, and she, oh, God bless her, I mean, really, she was in rough shape. She had done a living will, she appointed her granddaughter as power of attorney, and her granddaughter null and voided that, even though legally she couldn't, and then had a tube feeding put in her. And she lasted like maybe a month, not even, to put her through that. But apparently, I don't know. I have no idea if grandma ever talked to her about it. Maybe that's the only person she had. And I don't really fault the granddaughter for that, because it is a tough decision at the end to make. But it's always a good decision to sit down, have a frank conversation with the people you love, to let them know what you want and let them know, hey, can you do it? Can you not do it? It's hard, Andrea, and I don't know if you have siblings or not. It's hard too when you have siblings that aren't agreeing. Then that's even, makes it even harder. But to sit down and have those conversations. They're not always pleasant conversations to have, but they're necessary, right? Because, people come to their end of life, and you want to make sure their wishes are honored. And so having those frank conversations really helps. So very good question, Andrea. And I hope your father, I hope he's doing well. And, good luck with everything. So you guys are really, I got a very good bunch today. So thank you so much for your questions. But like I was saying, the healthcare surrogate always doing an alternate. I sign it, it's notarized, it's, this is who I've appointed. Again, those healthcare surrogates that I've appointed, they cannot appoint somebody else. They can say, you know what, I can't make this decision. Hey, cousin George, come over here. I want you to make. No, 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 no. I'm the only one that can appoint somebody to make healthcare decisions for me. And so those healthcare decisions include everything: surgeries, end of life, all of that. And those, again, if you don't want to give copies to people right away, you at least need to tell them where it's at. Oh, mom, and I also did a healthcare surrogate. Again, it's in my right desk drawer under lock. The key is in the drawer, blah, 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 blah. Remember back in the day, and I don't think we have them anymore, safe deposit boxes? Remember those? I don't think we have them anymore. But anyway, my parents, way back in the day, had all their documents in a safe deposit box. And I said, okay, well, who has access to that? We do. Okay, well, that's not going to help if something happens to both of you. Then it's very costly to get into that safe deposit box. You got to get a court order to get in. And then if you don't have a key, you got to get a drill, and it's all very costly. I said, get somebody else's signature on that safe deposit box. So they did, my brother, but I think they've since cleared it out because I don't think banks have safe deposit boxes anymore. And they now have them. When I was up there over the summer, I made sure to go through all their documents, make sure they had everything. Oh, they were scurrying around looking for a whole bunch of stuff. And the house is like this big. So I don't know where they would keep it, that they required all that effort. But anyway, so you make sure that you keep it in a safe spot. Now, what I always do with my clients, of course, is I always give them the original of everything. I never want to keep an original because who knows where I'm going to be when something happens. I'm not family, I don't know. So I always give them an original and I say, how many copies do you want? And they'll give me number 3, 4, 5, whatever it may be. We make those copies and then we always keep a copy of everything in the event that they need it. Maybe they lose the original, which happens a lot. And then we send it to them so that they can have it or send it to their family. Like I recently had one of my clients that I did a will for. She was passing away and her family contacted me to say, hey, we need these documents. I'm the named power of attorney. So I provided them to them and she passed peacefully. God bless her. So anyway, so that's a healthcare surrogate. The difference is surrogate, proxy. Proxy is when a facility or a hospital or somebody has to appoint somebody to make decisions for you because you never did. And they just make healthcare decisions, at least here in the state of Florida. I don't know what a healthcare proxy is in the rest of the United States, but that's how it is here in Florida. And then a healthcare surrogate is where, again, I'm competent. I can make my own decisions. I'm not incapacitated, and I've appointed somebody and an alternate to make healthcare decisions for me. Okay, excellent questions. All right. My next topic, living wills. Now I get this a lot. Hi, I'd like to do a living will because I want to make sure that my children get my house when I die. Okay, well, that's not a living will. Now, let me explain to you, which is an easy way for me to remember and for me to let my clients know the difference. A living, take that word, living. I'm alive, and a living pertains to my body. My body is alive. My body is living. So a living will. This is what I want done with my body while I'm alive. Now, to have a living will come into effect, meaning it doesn't come into effect like that. Like, oh my gosh, look at, she's coughing. Well, let's pull her off machines. No, for a living will to come into effect in the state of Florida, again, you want to get with your, estate planning attorney in whatever state you're in. But in the state of Florida, two physicians have to certify that 3 conditions exist. You're in a persistent vegetative state, what we used to call coma, right? Coma, you're in a coma. You're in an end stage condition, meaning there's really no hope of recovery. You're end stage. And you're end stage and there's no hope of recovery. You're in a terminal condition. Those 3 conditions have to exist, certified by 2 doctors for living will to kick in. So let's say you're in a car accident and you go into cardiac arrest. They're not going to go, oh, oh, she has a living will. No, they're going to do, because that's an emergency. That's an event. They don't know what your condition is. They don't know if you're persistent vegetative state, your end stage condition, or your terminal condition. They don't know that. They're going to work on you. A living will says those three things. I want to be kept comfortable. I want to be kept pain free. I just want to go peacefully. Now, in the state of Florida, we have a pretty simple living will. You just sign those three things. If I'm in a persistent vegetative state, end stage, terminal condition, then you've got it covered. There are some lines that we put in our living will here in my office to include anything that may be no tube feedings, or no chemo or no radiation or whatever. But of course, if I'm competent, I say, I want radiation, I want chemo, I want all that. Of course, I'm able to do that because I'm competent and I'm able to make that decision. But the living will comes into effect if you're incapacitated. So, hey, Rick, how are you? Good afternoon, Attorney Sterling. Good afternoon. My question is, can specific medical treatments or interventions be outlined in the living will? Thank you. Oh, you're welcome. Excellent question. As I was just saying, you sure can. There's all kinds of different wills, living wills out there. There's something called 5 wishes I've heard of too. I've never used it. I've had people bring it to me, where you kind of say what you want. You can be very specific in your living will, or you can just be general. Hey, if I fit these three things, I just want to be kept comfortable. But let's say, Rick, you want to ensure that you at least get intravenous fluids if you're ever, incapacitated or in an end stage condition, no hope of recovery, and a persistent vegetative state. You want to make sure you at least get some liquids. You can put that in there. Please administer IV liquids toward, until I pass, just because that's what you want. Some people have religious convictions, maybe. They don't believe in some things, but they do believe in others. So they want to spell that out. That's perfectly fine. It's whatever you want to do. This is you verbalizing to the world what you want done if you fit, at least here in Florida, those 3 criteria. So yes, if you sit down with an estate planning attorney, you want to make sure they know that, hey, this is what I want done for sure, to make sure that I pass peacefully. And this is what I don't want done, what I definitely don't want. Like, let's say, Rick, you say, well, I don't want to have tube feeding. I don't want a nasal gastro tube feed through my nose. I don't want one through my stomach. I just don't want that. I want to be kept comfortable, but I do want fluids administered to me. So then they know to do that. You're giving them directions. And also, Rick, you're giving directions to your family and your loved ones to know what exactly you want so they can make sure that your wishes are granted. So excellent question, Rick. Thank you so much. I hope I helped you. But the living will, like I said, again, it doesn't come into effect until you fit those criteria, at least in the state of Florida. You'll want to check your state to make sure. But I know over the years with my parents, as they're getting older, I have those conversations with them. I know what they're wanting. I know what they don't want. And it's hard as a child to say, oh gosh, making that final decision. I always tell my parents they got the trifecta, right? They have 3 kids. They have, my oldest brother is a nurse, I'm an attorney, and my younger brother is an accountant. How could they have it any better? But anyway, the living will helps with the family making those decisions. And again, I've had family members come in and, oh, they didn't know what they were doing when they signed this. They didn't understand. Well, we don't know because now they're incapacitated and they're in a persistent vegetative state. We can't ask them. We can only know that this is what they wanted because it's signed by them. There's 2 witnesses and there's a notary. The notary obviously signs that the person is who they are. And this is what they wanted, and these are their wishes. And to go against that, and like I said, I know it's hard, it's emotional and all of that, but we need to remember that, this is somebody saying what they want and helping them with their end of life. So that's why I say it's always a good idea to sit down and talk with your loved ones to make sure they know what you want. So All right, now we're going to go into. I know I didn't do a video on this because I made a trip up to Minnesota. As I said, it was chilly. It wasn't bad the first few days, but then it just went downhill from there. But it's beautiful up there, so it doesn't matter. So I didn't get to do a video, or I didn't do a video because I wanted to show you all the fall colors about wills and trusts. So going from living wills to an actual will. A will does show how you want your house to go, or how you want your car, or how you want your wedding set, or your money or your accounts. So a will says, this is what I want done with my things and stuff. I like those words, things and stuff. This is what I want done with my things and stuff. A living will has to do with my living body. The will, a standalone will and testament, we kind of call it to be formal. A will and testament has to do with my things and stuff. So my things and stuff need to do this. Go here, go there, go everywhere. Now, when I have somebody come in and I talk to them about a will, I go over everything with them because I'm going to give you a little secret about how to kind of avoid things going through probate and avoid fighting. I don't know if you can ever truly avoid fighting. If people choose to fight, they're going to fight. It doesn't matter. It really doesn't matter. So you could feel you have an ironclad, nobody's going to fight, nobody's going to have a fuss. But if people are going to fuss and fight, they're going to fuss and fight regardless. So you just need to think about what makes you happy. But the will directs where everything goes. So I wanted to go here. I wanted to go there. Then you also appoint what we call a personal representative. That's not a power of attorney. When somebody dies, that power of attorney, whether it's a specific power of attorney or it's a durable power of attorney, it dies. You no longer have authority. I just had a gentleman come in. Well, I have the power of attorney, but nobody will honor it. That's because the person passed away. Now it reverts to the personal representative, who was appointed as personal representative to ensure that things and stuff get distributed correctly. Oh, I'm getting dry. How do things get distributed? That is that personal representative's responsibility. There we call it fiduciary duty. Their fiduciary duty is to the beneficiaries. Now, they can always be a beneficiary as well. Let's say, like me, I have one child. That's it, the golden child, right? And he would be my personal representative and my beneficiary. So he's got a fiduciary duty to himself, right? But that personal representative has a fiduciary duty to all the heirs, all the beneficiaries, to make sure that everything is taken care of, everything is rallied in, and everything is divided how it should be divided. So that's what a will does. It divides your things and stuff. So to avoid having to go through that will and finagle through the probate and all of that kind of stuff, you can always put beneficiaries. What do you mean beneficiaries? Beneficiaries, you have bank accounts at the local bank here in Florida, Bank of America, Wells Fargo, whatever it may be, and you can put beneficiaries on your bank accounts. They have absolutely no ownership to it while you're alive, but when you pass away, it automatically goes to them. No probate, no fight, no nothing. It is theirs. And generally, which most banks do is an acronym. And let me tell you what the acronyms could be. T as in Tom, OD, that's transfer on death. ITF, in trust for. P as in Peter, OD, payable on death. So it would show that on your account. It would show Laura Sterling, POD, my parents. So my parents, my account is payable on death to my parents. So it doesn't go through probate. It doesn't have to do anything. It automatically becomes theirs. All they have to do is provide identification, a death certificate, probably fill out some paperwork because everybody has paperwork nowadays, and the money's theirs. So I always try to get my clients to do that because, one, it's easy access money. So if you pass away and there's bills that need to be paid, maybe funerals, stuff like that, that's taken care of pretty quickly with the money because there's liquid money there. So, and two, it's less to have to hassle with in probate. Also, if you have investment accounts or retirement accounts or whatever, put beneficiaries. Call everybody, Marilyn, Shaw, Raymond James, whomever it may be, to make sure that you have beneficiaries if you're allowed to put beneficiaries on those accounts. Because then when you pass away, all the beneficiary has to do is present identification, death certificate, and again, the paperwork, and they're the beneficiary. A check is written to them, and it's all said and good. Otherwise, what you have to do, if you have those accounts and there's no beneficiary, you got to go through probate. I one time had a mother come in, God bless her. Her son had passed away. He had a life insurance policy. We all know what life insurance is, right? Life insurance is okay. I have this life insurance policy. I name a beneficiary. So when I die, the beneficiary just has to get with the insurance company. Again, ID, death certificate, and paperwork, and they get a check issued to them. Clean and easy, right? Well, he had a life insurance policy. He named his dad as primary, and that was it. And guess what? Dad passed away before he did, and he never changed it. So mom had to probate it, and she probably shouldn't have had to do that. And oh, God bless her. She was so sweet. And having to go through that and pay the money for that to get that check, because otherwise the life insurance policy is not going to issue it. If they do, they're going to issue it in the estate of Laura Sterling. Who can cash that? Only me. If I were alive, nobody can cash the check. So you have to open a probate. You got to put it in the probate account. You got to do all that kind of stuff. So that's one way to kind of avoid all of that, is to put beneficiaries on as much as you can. Now, sometimes it's hard on a deed. We usually talk about like life estate deeds or labor deeds or beneficiary deeds, for lack of a better word, to put so somebody's a beneficiary to that house. And that's best to talk. I'm not going to get in too much detail because it gets kind of confusing. I know the laws here in Florida, but I don't want to confuse you all if you're in other states, because it's really best to talk to an estate planning attorney in your state to talk about which deed is best for you. I know we call it one thing here in Florida. They call it another thing in Minnesota. And the only reason I know that is because I went through that with my parents. So it could be very different, varying on different states. So just check into those. How can I avoid probate? How can I do it? What can I do to not have to have that costly expense? So that's just a little tip. Again, you might want to get with an estate planning attorney in your state to find out other ways. So, hi, Johanna. Oh, I like your name. Everybody looks like they're kind of in a cold, except for, who was it, Andrea? Andrea wasn't some, but Johanna, I like your hat. Hello, what happens if someone becomes mentally incapacitated and does not have a power of attorney in place? Very good, Johanna. You might want to check my live from last month. It's still on Facebook and still on YouTube. We talked about guardianships, and that's probably going to be the best bet, is a guardian, to have access to finances, and to make medical decisions. Now, medical decisions, let's say, Johanna, it's your mother and she become mentally incapacitated, and your father, passed away, and you're the only child. They're going to naturally go to you to make healthcare decisions because you're kind of in that succession as the child. But financially, nobody's talking to you. You can go and say, but I'm the daughter. I'm the daughter. They don't care who you are. They're not talking to you. Social Security, pensions, banks, nothing. They're not talking to you unless you have a legal document that says that you're a guardian. And that's a court process. So that's why I always tell people, it's a lot less money to get a power of attorney in place than it is to go through the guardianship process and, court and all of that kind of stuff. And putting a power of attorney in place alleviates that stress. And then you have that in place. So they become mentally incapacitated. You can just provide that. A lot of times I will go in and I'll have people in facilities and they sign power of attorneys. I immediately, on their behalf, with their permission, of course, go to the nurse's station and say, can I have you make a copy? You keep one. She wants you to keep one on her record so that you have a copy. And then I have a copy. And again, like I told you, I give it to my client along with the original. So very good question. I hope everything's okay. I hope that you're dealing with what you need to deal with. And again, if you need any help, if you're here in Florida, I'm here for you. If not, check with an attorney in your area. Thank you so much, Johanna. Okay, so you guys have good questions. This is a good little topic. So again, a will, things and stuff. Living will, body, my living self. Now, a trust. What's the difference? What's a trust? What's a trust? A trust is always, at least in the state of Florida, I place a trust, or I talk to my clients about a trust when they don't want somebody to get something right away. Because in a will has to close, meaning here's everything, everybody has what they need, and we're closing the will, we're closing the estate. A trust doesn't have that. I mean, a trust can't last in perpetuity. Perpetuity means forever. But a trust, at least, okay, let's, my son, my only son, the dream child, is 25 years old. Let's say, God forbid, something happens to me tomorrow and I pass away. I don't want him to get everything at the age of 25. I say, he's still young, because to me that's a baby, being my age. I'm not going to tell you how old I am, but 25 is young. So maybe I want him to get this right now when I pass, but there are certain milestones I want him to reach before he gets the rest. I can do that in a trust. I can spell that out in a trust. I can say, okay, when he wants to buy his first house, he can get $10,000 as a down payment towards the purchase of that home. So that's 10,000. He purchases a home, it's 10,000. But there's still money left in the trust. It stays open because the next criteria is when he gets married. If he gets married, that he will get 10,000 towards the wedding costs. So boop, there you go. That's there. So that 10,000 is paid out. Then I have some more money. So I don't want him to get it until maybe his first child is born. When your first child is born, you get 10,000. Here you go. And so I'm putting parameters on how I want the money distributed. Because I'm telling you right now, at least here in the state of Florida, and I believe throughout all the states in the United States, when somebody turns 18 years old, they're an adult. I know. Think about what you were doing when you were 18 years old. I mean, let's say, God forbid, your parent had passed away, you turn 18, and now it's all flooding at you, the money, the property, everything. And you're 18 years old, and you're like, woo woo, party, and you wipe it out before you turn 19 years old. So that's why people do trusts, because they say, there's a lot here. I don't want my child when he turns 18 to blow it all. So I want to set up a trust where it's in stages. Maybe that this 18-year-old, when he graduates from high school, when he enters college, when he graduates from college, when he gets his first job, when he goes to buy his car, could go on and on and on, right? I mean, it has to end at some point because the money's going to run out at some point, unless you're like a, multimillionaire and it just lasts forever. Lucky you. But a trust is very specific as to when the money is to be paid out. Now, again, the trust can just say, hey, my son's 25 years old. When he turns 35, just give it all to him. Just delete the whole thing. He can have it all. He can go hog wild with whatever he wants to do. But it leaves it open. It can be left open, where in a will it can't. Now, I'm going to go into something a little specific to Florida because I do like to touch on this, even though it's not the case in every state. Florida is very unique in this area. Your home, you live in a home, you have a homestead here in Florida. I am currently in my homestead because the internet seems to work better here with my live than it does at the office, but I am in my homestead. So when I pass away, this is protected homestead, meaning my creditors can't come after the home. Hey, there's no money in the estate. We want the house. We want the house. My American Express or my car loan or my student loan or my, I don't know, whatever I may have out there. They can't chew after the house. They can't take parts of the house. It's protected homestead. And so with a protected homestead, you can devise it. You can devise it to your next of kin. So my son, I can say, I want my homestead to go to my son. It will pass clear of creditors to my son, and he will now have the house. Now, if he doesn't have a homestead in Florida, he could claim that home as his homestead. If he does have a homestead and he wants to keep my homestead as rental property or whatever it may be, that's when I start recommending trusts as well. Because in Florida, when you can only have one homestead. That's it. One. Uno. That's it. You can only have one. And so, with that protected homestead, if you get another piece of property, that is not protected. That is not protected from creditors. Creditors can go after it. So, that's when I start talking to people about you need to do a trust, because then you can put it in the trust and you can protect it. Do it that way. So, that's kind of a unique thing we have in Florida, a protected homestead. I always, when I talk about that with my clients, I use the example of a pen. See how this pen passes from one hand to the other without, see how easy it does that? It just seems to go freely back and forth. That's a homestead here in Florida. As long as it's passed the correct way, that home just passes back and forth. Now, that doesn't mean the mortgage goes away. Obviously, there's a mortgage there. And so, what you would do is get a mortgage to take care of that mortgage, get a mortgage in your own name. The mortgage doesn't automatically poof, it's gone. So there's still a mortgage. You got to deal with that. What I have a lot of times people do, and they come to me, maybe mom or dad passed away a few years ago and they never did a probate. And so maybe somebody's been living in the house, in mom's house, and now they want to sell. Well, they can't sell because it's still in mom's name. It's in mom's name, and you got to get it passed to somebody else so they have the right to sell it. Or what they do sometimes, God bless them, they start quick claim deeding it. They start deeding that house out to different family members and stuff. And so there's like 6 or 7 deeds out there that have been gone around because they feel, oh, well, mom died, so it's my house. But no, you can't do that, because then you go to sell it and now you don't have clean title because you got like 6 or 7 deeds out there. The house has to pass through a probate, just like a pen from hand to hand. Here in Florida, we do something called a petition to determine homestead. And then the court approves it as long as it fits the elements of a homestead, and it'll pass free and clear of the deceased person's creditors. So those are times when I talk about trust, when there's other pieces of property here in Florida, at least, when there's other pieces of property out there that you want kind of protected, and you want to make sure it goes to specific people, or you don't want everything to go to somebody all at once, you want it to be spread out. That's when I talk trust. So those are the differences between wills and trusts. Now, I kind of went over it. It's a lot. And when I sit down with people to discuss all these things, I really take a lot of time. I map it out for them. I always give them homework as well. I'm a big homework because, I teach at the university, so I'm big into homework. I always give them homework to say, okay, these are the things I want you to check into. I want you to check your Raymond James account. I want you to check your bank account. I want you to check your life insurance to make sure that you have beneficiaries on those and that you have alternate beneficiaries in the event that something happens to your first beneficiary. Or maybe you have 4 kids and you want it split equally. And then what happens if one of them dies? You got to make sure, God forbid, you got to make sure that you redo your beneficiaries, because let's say you have 4 children, each of them gets 25%, but one of them, God forbid, passes away before you. Guess what? That 25% you got to deal with. It's not automatically going to go to the other 3, and it's not automatically going to go to the children. Something has to be done with that, either that's probated or whatever. But it's good to always look back and go, okay, alrighty, now it's, what is it, 33%. So you always want to look at that stuff. You want to make sure that everything is in place. You want to make sure that you know what you need, that you've had these candid conversations with family members and loved ones, that they know what you want. A lot of times people don't like to talk about it. One time, a little lady, she was so sweet. She came in, her son brought her in, and she didn't want to do a will or anything, living will. Well, then I'm going to die. And I said, ma'am, unfortunately, you are going to die. I mean, yes, you will. But you doing a power of attorney, a living will, and a will, that's not going to make you die. It's going to make you feel at ease so that when something does happen to you, I do know that things are taken care of. And I get a lot as well, people coming in and saying, well, if I die, the state's just going to take it anyway. There's nobody in the state that takes things. What may happen is the bank, if nobody ever claims the account and there's money in there, they may send it to the state for unclaimed. So one day, someday down the road, somebody, when they open a probate, can claim that money. So those are just kind of things that I see a lot of times when people come in. So kind of a recap, because we're getting to the end. I always get winded. We talked about power of attorneys. We talked about, again, my list, specific power of attorneys for certain things: selling my house, selling my car, dealing with my bank. Once that's done, it's done. It's null and void. Durable power of attorney. That stays in effect even after I become incapacitated. And it covers certain enumerated issues, banks, all that kind of stuff. Like I said, ours is about 22 points that we do there. Again, that can maintain. And again, those both come into effect the moment you sign them. And again, that you have an alternate, that you appoint an alternate. Power of attorneys. Then we talked about healthcare surrogate. Healthcare surrogate. I, me, myself, and I, just like with the power of attorney, am appointing somebody to make healthcare decisions for me. Like my questions asked, hey, but what happens if it goes awry? Well, that's why you want to sit down and have a talk with the people that you're appointing. Also, in a healthcare surrogate, it doesn't come into effect right away. You have to not be able to make decisions for yourself. You're incapacitated, persistent vegetative state. The doctors will always come to you first. If they can't get from you, they're going to go to your healthcare surrogate decision maker. And again, your power of attorney and your healthcare surrogate cannot appoint anybody else to do that. You would have had to have done it and doing an alternate as well. Then we had the living will. The living will, living, my has to do with my body. What do I want done with my body when something happens, when you have become, at least in Florida, unable to make decisions, persistent vegetative state, terminal condition? What do I want done and how do I want it done? Being as specific as you want or general as you want. So that's the living will. A will, my things and stuff. Where will, this is a good thing to remember too, where will my things and stuff go when I pass? In a will. You spell it out. Then the will closes. You have to put a personal representative, somebody that's going to make sure your things and stuff get distributed. They have a fiduciary duty to the beneficiaries. That's a will. A trust can stay open, I don't want my 25-year-old to get it right away. I want to spread it out. This is what I want to do. I also want to protect my non-homesteaded properties here in the state of Florida. That's what we talked about. Now remember, I'm talking from the state of Florida, so a lot of things I spoke about are kind of Florida specific. So make sure if you're not in the state of Florida that you get with an attorney, an estate planning attorney in your state so that you can get the appropriate laws in your state. But please, if you live in the state of Florida and you have any questions whatsoever about estate planning, we're here to help. Please feel free to give my office a call. I'm more than happy to talk to you about it, even if it's just a talk so that you have it right in your mind what exactly you want to do. Because some people come to me, they want to talk about it, they want to work it out, then think about it and then come back, or talk to family and then come back. So make sure that you get everything straight. Give us a call if you have any questions. Again, you can watch my podcast on Spotify. I'm on Instagram. I'm on Facebook Live. I'm doing a blog now. I'm on YouTube. And I'm still here in the state of Florida. Have a great Halloween and boo.